Welcome back to the DYK podcast discussion series. In this week's episode, we sit down with advocates from the Yale Law School's Media Freedom and Information Access Clinic to discuss their work on government transparency issues. MFIA is a law student clinic dedicated to increasing government transparency, defending the work of news gatherers, and protecting freedom of expression by providing free legal services, pursuing impact litigation, and developing policy initiatives. In February of 2023, the clinic filed a Freedom of Information Act lawsuit on behalf of sports journalist Daniel Libit against West Point and its offshoot organization, the Army West Point Athletic Association. Mr. Libit had previously sought sports-related financial and contract records from the West Point entities under FOIA. FOIA applies to federal agencies. West Point denied Mr. Libit's requests, claiming that all records were in the possession of its separate athletics association, which it claimed is a private entity not subject to FOIA. The West Point case is a perfect example of how public entities in big-time college sports increasingly use separate and allegedly private entities to shield documents and information from public disclosure and public scrutiny. In our discussion, former clinic director Kelsey Eberly and Yale Law students Amara Banks, Aisha Durrani, and Taiwo Desunmu offer insights into government transparency issues broadly and also walk us through the West Point litigation. This episode was recorded on March 7th, 2023. Several months later, the clinic prevailed in its suit. In an effort to avoid litigation fact-finding and a trial, the West Point Athletic Association agreed to a court order to provide the records under FOIA. The Athletic Association also agreed to respond to future records requests from the public as if it were subject to FOIA. Despite these concessions, the association continues to maintain that it operates outside FOIA as a legal matter and reserve the right to raise that defense in the future. Congratulations to the clinic for achieving a swift and successful result in the litigation. Kelsey, Amara, Aisha, Taiwo, welcome to the DYK podcast.
Thank you.
Yeah, it's great to have you all here. And Kelsey, you're a clinic director and a clinical lecturer in the program. But before we get into the nuts and bolts of what the clinic does, I want to have the students introduce themselves, maybe give a little bit about your background, where you went to school as an undergraduate, what year you are at Yale Law School, what your curricular interests are, and then where you may see yourself on the backside of your legal education. And Amara, if you could lead us off with that.
Sure. Hi. Thank you for having us. My name is Amara. I'm a first-year student at Yale Law School. I'm originally from California, but I went to undergrad in New York City at Barnard College. And I'm interested in technology, digital privacy, intellectual property law, and I hope to, in the short term, practice in that area as an attorney, and in the long term, possibly work in the regulatory or government space.
Great. Aisha?
Hi, my name is Aisha. I'm a 2L. That's a second-year student. I'm from Pennsylvania. For undergrad, I went to Johns Hopkins, big pivot to a school like Yale. And I am kind of interested in all aspects of the First Amendment. I've done a little bit of religion work, now a little bit of speech work with MFIA. And I think down the line, I'm interested in litigating around these issues.
Great. So you pronounce the acronym MFIA? Nice. You guys are tough.
Yes, that's
right. You
right.
guys are tough. Taiwo.
Hi, and thank you for having us. My name is Taiwo. I am from Washington, D.C. I went to undergrad at the University of Michigan. I'm also a 1L like Amara. And after law school, still trying to figure it out, but broadly interested in government service, perhaps working in kind of civil rights or voting rights.
Wonderful. Wow. Impressive credentials. So Kelsey, if you wouldn't mind talking a little bit about the clinic's work, and I'm just going to refer to it as the clinic, and its history, the types of cases that it typically takes, what the points of emphasis are semester to semester, and importantly, what the students' roles are in the clinic.
Sure. So the Media Freedom and Information Access Clinic is one of several student-run clinics at Yale Law School. And it was founded in 2009 by 4 Yale Law students with a really unique mission. It arose out of this moment when print journalism was sort of waning and, digital journalism was rising, and increasingly investigative reporting was being done by, freelance reporters. And these students really saw the need for, pro bono legal services for these reporters who were going out and, breaking stories, perhaps without, the support of large or traditional media organizations. And so the clinic has really grown from there to work on a broad variety of cases and projects, all related to news gathering, protecting, freedom of speech, the freedom to gather the news, and then also this sort of second focus on government accountability and transparency. So, seeking public records and using the Freedom of Information Act, as we'll discuss. And the clinic provides pro bono legal services to, a broad variety of journalists, academics, nonprofit organizations, and we pursue impact litigation as well as policy work. At any given time, we're sort of doing a mix of all of that. From semester to semester, we have, a variety of cases that fall within that sphere. And one of the coolest things about the clinic is that the students, do all of the substantive work of the litigation, of the policy work. Wow. They're the ones doing all the research, drafting all the briefs. They really drive the cases and projects forward and really own, the achievements of the clinic. So we're really proud of that.
Yeah, so we're going to talk a little bit about a sports-related case that you have involving one of the service academies. Have you done any other work in the sports-related context? Because it sounds like you have a pretty broad scope in terms of the substantive area that for a case that you're working on. But is this your first sports-related case?
I believe it is. When I asked that question of our clinic director, he couldn't remember another one, and so this might be our very first sports-related case.
But as we're going to discuss, so many of these issues really transcend sports and go to the heart of our freedoms and our democracy. And I want to talk a little bit about how the clinic work complements the students' coursework and the constitutional law classes, First Amendment classes. I'm not sure how Yale structures their curriculum, but maybe if one of the students could join in and explaining how the clinic work kind of fits in to their curricular work. And Amara, maybe you could help us out with that.
Yeah, definitely. I think this clinic touches on a couple of different courses that I'm actually taking this semester. One of them is my legal research class. And in the clinic, we do a lot of work with different authorities like cases or statutes or other secondary sources to orient ourselves on the case and on the law. And so knowing how to find that information quickly and effectively and accurately is actually a skill and a bit of an art I've been learning. And so I've been drawing on the things and techniques that we've been learning in that class as I have been working on this matter and other matters in the clinic. In our first semester of law school, we all take civil procedure, which also orients us on the laws of civil procedure and how to file a lawsuit in federal court. And it's been really cool to deploy the things that we learned in that class in this clinic, as far as just knowing which court to file the case in, knowing what the deadlines are for the parties to answer or to make different motions or what kinds of motions they can make. So it's all very interactive, and we've been putting the things that we've learned in that class to work in this clinic in real time.
And you take con law your first year, I assume?
Yes, we do.
How far do you go into con law in your first year at curriculum, or where are you now?
So we took con law in our first semester. I would say that I don't draw on the things that I learned in constitutional law as much as some of the other courses that I mentioned. There is a connection there with the First Amendment. And maybe Kelsey, if you want to jump in here about the qualified First Amendment right to access. But generally, I think that the things that I use most in my other courses come from my legal research course, civil procedure, statutory interpretation as well can come into play at times. The FOIA statute is a bit straightforward. I know some states phrase it differently, but that's another course that I'm taking that overlaps a little bit with the clinic as well.
And Kelsey, structurally, how does the clinic work? How often do the students meet? Do they have a component where you're lecturing, you're teaching? And then do you have topics that you emphasize from semester to semester?
Yeah, so we have a seminar in the clinic and we meet every week, and we teach a mix of practical litigation skills. So, things like oral advocacy and legal research and writing and, discovery. But we also teach a significant amount of, the core substantive law that the students need to really excel in their casework. So that's everything from, the First Amendment access law. So, how do you, if you're a journalist who wants to get access to a judicial proceeding, what are your rights and how do you do that? To the Freedom of Information Act, of course, to various First Amendment doctrines. Like we just did a class about government gags, when government speech restrictions on government employees restrict journalists' ability to interview government sources. So what we cover is generally driven by what we're working on in the cases. So, we want the substantive law to have direct application to the work that the students are doing for our clients.
Yeah, and you just mentioned that there isn't necessarily a constitutional right of access that's protected, but most public records laws have First Amendment values, even if they're not necessarily legally protected. They're implied in access. And maybe Aisha and then Taiwo, if you could talk a little bit about how you see the values that underpin FOIA in this context, because the case we're going to talk about is a federal case. It's a FOIA case. And the importance of those values, particularly as you're analyzing this complicated statutory language, sometimes it seems like the values underlying public access can get obscured in that kind of analysis. Aisha, do you have any thoughts on that?
Yeah, I think that the language of FOIA makes clear that Congress found incredibly important that the American people can access information that impacts them. Mm-hmm. And the only thing that the government can withhold when it comes to that information is bits of information that fall within very specific exemptions. And I think we have found that, at least in this case, it feels like, parties can take steps to hide information that doesn't seem to fall within the language of those exceptions, which are very clear. There's like a national security exemption, for example. And the information that we're trying to get in this case doesn't fall within any of those exemptions. And that feels so contrary to the spirit of FOIA, which is so clear and so straightforward and so accessible to the average American.
And actually, that leads me to another question I wanted to ask all of the students, and I'll start with Taiwo. When you started your work with the clinic, did you have any preconceived notions really at the values-based level about transparency and accountability and whether government entities were openly, sharing documents that really are owned by the public? That's one of the fundamental underpinnings of public records laws, right? Did you bring in any preconceived notions about transparency and accountability in government?
It's a good question. I'd say I came into the clinic and I came to law school in general with some experience kind of working with government agencies. And I'm a pretty firm believer that the folks working in government are, generally speaking, doing their best and are trying to serve the public as well as they can. But we see time and time again that things happen and that even well-meaning public servants can make decisions that lead to really negative outcomes. And it's so important that journalists are able to do the work that they do to serve as an effective check, but also just to make sure that there's efficiency in the system. There's a necessary role that the public plays, that journalists play in holding politicians accountable, even if it's not a question of kind of malice or deliberately trying to hide things. But transparency in and of itself plays a really important role in the functioning of government. As I've gotten to learn more about FOIA, and certainly as I've seen kind of the dynamics in this case and some of the other cases, the sense that I have of how critical these roles are, these statutes are at all levels of government, it's only growing.
Yeah. Amara, how about you? Did you bring in any preconceived notions about transparency and accountability and the willingness of government entities to respond appropriately to requests for public information?
I will say my background was mostly in the private sector coming into law school, so I don't have any direct experience or exposure to government entities when it comes to disclosure and transparency. But in college, I was a student reporter on a campus news website and definitely learned firsthand the importance and value of cooperation and transparency from the administration, just in the context of our little community. And so thinking about, the bigger world and the bigger administrations that govern our lives, which is the US government and state governments, I definitely think it's important that they are transparent and do cooperate with journalists to strengthen democratic accountability and for people to have more faith in the value of our system.
Yeah. Aisha.
Yeah, I encountered FOIA like several times before I came to law school.
Okay.
It's been a favorite of mine for a while now. But I think especially in some of the national security related work I did before law school, I realized very quickly how important it is for Americans to understand what the government is doing in their name. And I think I was really impressed by the tenacity of the lawyers who fought for that information. There are so many parts of American history where we know that information has been withheld by the government, sometimes improperly, and that information, when it does come out, when it does see the light of day, we realize how impactful it is. So I think, I feel really lucky to be a part of this clinic because this is work that I have always really admired.
So before we get into the Army case, could we just walk through some of the nuts and bolts, the ABCs of public records laws? And target audience with the DYK Media Project are college athletes. And there's so much going on in the regulation of college sports and the legal aspect of it. There's some other transparency issues. Transparency is a big problem in college sports. You're seeing one slice of it, but it's broader than that. And we really want to try to shine a light on that in our work. But a lot of college athletes probably don't know what FOIA is, don't understand the kind of the basics of public records law and the importance of transparency and the ability to get accountability from our public institutions. So if you could just kind of walk us through some of the basics, who it applies to, public, private, what the statutes do for the most part. And although we're talking about FOIA, there are a lot of state laws as well. So if we could just talk a little bit about that kind of Public Records 101. And Aisha, if you wouldn't mind leading us off on that, and Kelsey, you can weigh in as you see fit.
Absolutely. So FOIA is a federal statute that was passed in 1966. And it allows private individuals or entities, so people like you or me, to request the disclosure of information or documents from federal government agencies. And like you alluded to, some states, or actually all states, have similar freedom of information statutes that apply to state agencies. And sometimes those have different names. They might be called things like right to know laws, but they work the same way and they have the same purpose. And that purpose, as you mentioned earlier, is ensuring a democracy where everybody has access to information. Like Lyndon Johnson said when he signed FOIA into law, a democracy works best when people have all the information that the security of the nation permits. And no one should be able to pull the curtains of secrecy around decisions which can be revealed without injury to the public. Democracy works best when we, the people, have the information we need to meaningfully participate in society. And I think FOIA is really, really central to that. And as you mentioned, a little distinction is that FOIA applies to government agencies and agency records. So you can't FOIA request a private company. It's intended really for the people to access public information.
Right. And when you read that quote, that last clause, without injury to the public interest, when you read that, how does that land with you in terms of looking at FOIA? And then you have these broad principles of transparency. Then you have a long list of exceptions, right? That some transparency advocates have argued swallow general principle. You see that language, that qualifying language.
Yeah, I think sometimes it can be a difficult line to walk. There are some pieces of information that really are sensitive in nature and shouldn't be accessible to the public. But I think that by and large, information is almost always a good thing. And that principle, the real core of that principle is that when information is withheld, it's truly the exception and not the norm. And I think you see in a lot of cases, like the case we're going to talk about later today, that the information that's being withheld isn't particularly sensitive or damaging, and it's information that the public actually needs and wants to participate more fully.
So basically, if somebody could walk through the basic statutory analysis, what are you looking at when you're looking at FOIA and the documents that you're seeking? Kelsey, you want to talk about that? And maybe Taiwo or Amara can help out as well.
Sure. So as Aisha mentioned, the statute applies to agencies, which is a term that the law defines, and to agency records. And so agencies are basically all of the federal government, but not Congress and the presidency. So right. It's very broad, and it includes things like government-controlled corporations, as we're going to go on to talk about.
Yep.
And so agency records are those records that agencies create or obtain and have in their possession when someone makes a FOIA request, which is the common tool that people use to get access to these documents. So basically, the law provides several things. It provides a right for people to request records, of the agency records from federal agencies. It also requires that the federal government make certain information and documents affirmatively available even without a request. So it has this broad disclosure mandate. And then, as Aisha mentioned, there are, a number of exceptions, but those are to be narrowly construed. So the agency can't just say, I think this might be, a company's information. No, it has to meet the strict statutory definition. And because of an amendment to the law several years ago, it not only has to meet the exemption, the text of the exemption, but the disclosure has to harm an interest that the exemption applies. So again, the law really favors disclosure. It puts the burden on the agency to show that something is not an agency record, or that the entity to whom the request is made is not an agency. It puts the burden on the agency to show that records are exempt. So, in every relevant respect, it puts a thumb on the scale of the person seeking the records of their government and puts the agency sort of on the defense to justify withholding those documents.
Yeah, that's such an important point, that burden of proof reflects a policy in favor of openness and transparency. And then, of course, the motives of the requesting party aren't relevant, are they? Or they shouldn't be.
No, they're not. FOIA is for anyone and everyone. Anyone can submit a request for any reason or for no reason and seek records all the same.
So could you talk a little bit about some of the common objections and barriers to access that you find? Amara and Taiwo, maybe if you could weigh in on that. And you have one here in this Army case, and because this could be a good segue into that, where you have the entity saying, we don't possess those documents, somebody else does, and that somebody else is private, not public. And they're outside the scope of FOIA, state public records laws. Amara, could you talk a little bit about some of those barriers?
There are a couple hard areas where the government is not required to disclose information. Aisha mentioned one, national security. The organization is not a government entity. That's another one. I believe that there are nine official exemptions that the government can use to not disclose. Should we list them off? I don't have them memorized, Kelsey.
Yeah, you don't have to have them memorized. Yeah. And we'll land with the most important one. And Taiwo, if maybe you could kind of segue us into a discussion of the Army case with one of those important exemptions. Actually, I don't even know if it's on the list of exemptions, because that assumes that entity acknowledges that they're subject to public records requests. One of the things that has happened in other sporting contexts, not just this Army case, is movement away from public institutions into private portals, like conference portals. The Power 5 conferences are private entities. And with the Big Ten fall football decision, for example, you had flagship state university presidents and chancellors taking the discussion on fall football, moving it into the Big Ten portal so that it was not subject to public records requests. And, that's a problem. You have a similar kind of thing with Army. If you could talk a little bit about that case, what the issue is as it's been presented and as it's going to be litigated. You filed a lawsuit, correct?
Yeah, that's exactly right. So we filed a lawsuit, and amusing that you bring up the Big Ten portal. As I mentioned at the top, I went to Michigan and was reading some of the coverage. I thought it was amusing the way former President Schlissel, who was the head of University of Michigan when I was there, clearly did not understand FOIA and what it was meant to do, as he sought to send things over email that his peer presidents were like, maybe we shouldn't do that. But to your point, the purpose of that was essentially to hide their conversation about returning to campus, returning to the football season. So to pivot to Army and West Point, this case is largely about the distinction that Kelsey mentioned. For FOIA or the public records laws to apply, the agency has to be a government agency, and the agency has to have control over the records that are being requested at the time the request is made. So one of the things that our client ran into when he was making his records request was West Point was, and we'll get to this a little bit more, West Point was claiming that they did not control some of the documents that were being requested, and that instead they were controlled by the Army West Point Athletic Association, which is an affiliated nonprofit they established. And they claim it is not a government agency, it is completely separate. Therefore, the documents are with them and FOIA does not apply. So that is an example of exactly what you're talking about. Public institutions saying, although we had a role in creating these documents, perhaps, and in some cases they're not even admitting to that, but although we had a role in creating these documents, we don't have them anymore. So you can't ask us to give them to you. We are objecting to that in our lawsuit, suggesting a few different things, one of which is that Army West Point Athletic Association is completely controlled by West Point. Right. So to say that it's not an agency doesn't quite make sense. A little more broadly, there must be certain documents that are in West Point's possession that they are required by the statute to turn over to us. So that's the root of the litigation. And I think we'll talk a bit more about how this all came to be, but that is one way that organizations try to get around FOIA. I mean, that's what we're seeing here.
Yeah, and I learned about this issue from Dan Libit's article in Sportico, Why I'm Suing Army for Its Public Athletics Records. And I love Dan's work. He gives an interesting history of Army's attempt to create this separate athletic association. Some Power 5 schools do as well. The service academies really are in an interesting space in the mosaic of college athletics. And they're covered by federal law. All the other schools are covered by state law. But it sounds to me from Dan's article that he really got the runaround, and you could sense a little bit of frustration, justifiably. So I was frustrated reading the article at what Army was doing. If you could talk a little bit about the history of Army's decision and then the excuses that it's offered, the importance of the connection between the institution and this separate entity. And Dan mentioned another interesting component is that under NCAA values and in their constitution, the old constitution and the new constitution, universities are responsible at the institutional control level under the principle of institutional control. So you can't just chop that off when you create a separate entity. So if you could talk a little bit about the history of that entity and how you see the defenses that they've offered. Any of you, it's open to the floor, whoever wants to talk
I can
about
take that one.
Okay.
So yeah, what we found when we started looking into this was that one by one, the various service academies had basically gone to Congress and said, we're not able to compete with these huge athletic powerhouse. In order to have a competitive football program, we're going to have to raise a lot more money. And they had these constraints on them because they were part of the Department of Defense. And so they needed more flexibility and sort of more autonomy. And so they essentially asked Congress to help them create these dedicated nonprofit organizations that would basically serve as sort of their arm to run their athletics program and to more freely fundraise. And so that began the other service academies. And then West Point was the most recent one to seek that congressional authorization. And after they got that, then they started taking the position that because we have this entity running our athletics program, essentially we no longer have to provide any records, public records related to anything about athletics, because all of that is over there with the Army West Point Athletics Association, which is really, we as a two-step to avoid FOIA. Not only are they saying they don't have the records themselves, but they're saying the entity that does have the records that they control also won't give them to us. So it really stymied Daniel's reporting, and that's why we're bringing this lawsuit.
Yeah, and there was another element of that really troubled me, and that is that they create this ostensibly private entity, but then that entity isn't required to file a 990 tax return. So we don't even get that basic information. What's the status of the case? Maybe one of the students could talk a little bit about where things sit right now and what next steps look like.
Yeah, definitely. So we did a lot of research in the last semester as the appeals were not addressed and moved forward with filing a complaint in the Southern District of New York. So we compiled all of our exhibits, went through the process of filing electronically, which was my first time filing a lawsuit ever underneath the supervision of our awesome attorney, Kelsey. And now we are waiting for the Army AWPAA and West Point to answer our complaint. That will be the next step, or they can file a motion. There are a few different motions that you can file as a defendant in a lawsuit. And so the government in a case like this would have 60 days to respond. So now we wait.
You wait. Okay. So you haven't gotten their answer yet, their responsive pleading. So Aisha, you talked a little bit about this, but you said that what you were asking for wasn't that controversial or shouldn't be that controversial. I think that's true in a lot of these requests in the sports context, but you have this pushback. In the administrative process before you filed the lawsuit, did you get a sense of where they were coming from on these fairly innocuous requests?
Honestly, we didn't get a whole lot of them in our communication before we filed our lawsuit. As you can tell from Daniel's earlier article, they really gave us the runaround. Yeah. They gave Daniel the runaround. They did a lot of email follow-up. And that's really the core of the issue. There wasn't a justification for the decision. There was just a lot of bureaucratic, sorry, we can't grant this. Sorry, these documents are not ours. Sorry, these are housed with the AWPAA, and you can't request their documents either.
So, Taiwo, where things stand right now, they've given you a hard no. It's a private entity. Then they really haven't responded to the substantive requests in terms of whether there's some other exception. They're just saying the law doesn't apply. We're drawing this hard line in the sand. This is a private entity. If you establish that entity does have to provide documents under FOIA, do you then have to go then through a whole nother level of analysis and potential litigation over whether any of those documents fit into any of the exceptions?
Yeah, that's exactly right. They're not claiming a specific exemption. They're just claiming that they don't, not even that they don't have to give them to us, that they can't because they don't have them, which is somewhat, laughable, right? But you're right that the next step, assuming that we're able to get kind of a clear answer on these are agency records that are in the control of either West Point or an organization that West Point controls, then they potentially would have the opportunity to say certain exemptions apply, and therefore we don't have to give them to you. But as Kelsey mentioned earlier, the burden is on them to make clear that, one, a specific exemption applies to a specific document that they're trying to withhold, and also that there would be a specific harm resulting from the disclosure of that document or from the disclosure of that information, which, certainly it's possible that something like that might be relevant or might apply. But I think based on the subject matter, it's unlikely, although I don't really know.
Yeah, that raises some very interesting questions. But the point there is that you're going to have to go through a substantial litigation, it looks like, just to get to the point where they have to respond. And I'm guessing, this is open to the floor as well, that there's no legal presumption in terms of the production of evidence, burden of proof on this first threshold question about whether this entity is public or private. That's just, you're going to have fact finding, but they bear the burden of proving it's private.
I mean, our position is that they are an agency subject to FOIA. They are a government-controlled corporation, which is a specific entity that Congress says is a federal agency. And so it's their burden to say that they are not a federal agency that needs to comply with FOIA.
And in terms of precedent, what other types of cases are you looking at? Because a lot of these issues pop up, but not many of them wind up in litigation. That's one of the things I'm going to ask you about, Kelsey, in terms of the trends. A lot of times you have reporters who they make a request and it's denied, and you get the treatment that Daniel got, the runaround, and they go away. And I think my belief is that's part of the strategy: deny, delay, ignore. But there aren't many lawsuits. That's why the work you're doing is so important, because you provide that opportunity. So could you talk a little bit about kind of how frequent this type of litigation is, and what kind of precedent, what are you looking to in your experience to say that this is like this case or not like this case?
It's hard to say sort of how frequent litigation is. It is, even though we have this amazing federal statute that is this critical tool of democracy, like you said, when an agency chooses to delay or obfuscate or claim bogus exemptions, so often the remedy is suit if the administrative appeals don't turn things around. And when we do litigate, then we're lucky to benefit from a broad, body of case law that makes very clear that these agencies have to, be construing the statute broadly so as to fulfill its public disclosure mandate, construing the statutory exemptions narrowly. And so here we're going to be relying on case law that confirms that these that are subject to FOIA have to respond to FOIA.
Right.
It's not very controversial. And that corporations, either that are incorporated and controlled and exist solely to serve a federal agency, are government-controlled corporations that need to respond to FOIA requests. So, we're on solid footing. And so we're hopeful that we can get to that next step where we are getting some documents. That would be great.
Yeah. And I guess I want to go round robin on this with the students. Having applied these laws and the values that underpin them in a context-specific way, in real time, in real litigation, have your thoughts on government accountability and transparency changed at all? I mean, are you a little more skeptical now of government's receptiveness to sharing our documents with us based on the experience that you have in litigating this case and some of the tactics you've seen?
I mean, I would say that before I really dug into the logic, and we talked about this actually in our seminar at the beginning of the semester around public access and disclosure, I don't want to say blindly believed in the principle, but I just would always say, of course, the government should be transparent. Of course, we should have access to information. That's just what it means to be in a democracy and a free society. But we went through some exercises where we really unpacked how much more you are willing to have faith in your government and trust that things are actually being handled and addressed appropriately when you actually get to see what's happening behind the scenes.
Right.
And it just logically inputs into this equation of, yes, we have a healthy, functioning democratic society. Yes, our government is doing what we entrust them to do and believe that they're doing because we can see it and witness it and understand it with our own eyes that it's actually happening. And then you have just a more earnest, robust belief in things working as they should in the government. So that's kind of a lofty answer, but in thinking about it really logically and just going through the motion of like understanding how it all works together, I feel like I have a more robust and honest belief in the importance of transparency, and I see how it works directly with a transparent democracy.
Yeah. Taiwo?
Yeah, I mean, I think generally that the work of government and the work of government officials is really hard and really challenging. And I understand that there are like many reasonable and potentially like understandable reasons why a government agency would be slow or not responsive or even kind of default to wanting to keep things secret rather than provide it to the public. But the flip side of that is I have a pretty healthy belief that government officials and government agencies have like an immense amount of power and immense ability to do really good things. But that comes with an ability to do really bad things as well. Yeah. And that spans a huge range. I'm not suggesting that anything at West Point is like really bad, but you never know. And lots of institutions go through different kind of scandals of varying severity. And the only way to hold them accountable is to know what they're doing. And I would say like through the work of the clinic in this case and some of our other cases, I've definitely seen my belief in the need for outside either journalists or lawyers or both actors pushing government agencies as just ever more important and stronger, because it is easy, I think, when you're in government to default to less is more, when I think the flip side is really what, as citizens, we would want.
Yeah. Aisha, what are your thoughts on that? How have your thoughts changed, if at all, based on your experience in this case?
Yeah, well, I think because of my previous experience, I already came into this clinic, this case, really believing in the importance of transparency. But I think that working on this case has made me so awed by the role that reporters play in maintaining that transparency specifically. Lawyers are just part of a team, and the people who really drive FOIA litigation like this case forward are reporters like Daniel. He spotted this information, he requested it, and he brought us in later to assist when he got the runaround. And I think before law school, I always thought it was lawyers who did this work. I was like, lawyers, you have to be in the courtroom fighting for the First Amendment. And now I think maybe this is the maturity of law school hitting me. I realize that we have a role to play for sure. But FOIA isn't for lawyers. Like, it's for people. It's for reporters. It's for the average American. It's for anyone who wants information. And lawyers and law students like us, MFIA, the clinic, we're just here to help get that work done.
Yeah, that's very humble. The lawyers are really important in this, I think. Fighting the battle, you're taking up the charge. And, what I hear, and it's really inspiring, is that you guys are motivated. This experience has motivated you to hold our government to the standard, and the aspirations of these lofty laws. And so often, and particularly in the sports context, and I think that underlying a lot of the lack of transparency is this irrational fear about competitive advantage, disadvantage, like in the name, image, and likeness market. I don't know if you guys have followed that. The Power 5 schools aren't sharing any of their nil data, and there have been reporters who have made public records requests of those universities. And you get the whole litany of responses, including FERPA, the Student Record Privacy Act. But those universities don't want to provide those documents in large measure because they don't want anybody to know what they're doing, in a way that could compromise their competitive advantage, disadvantage. I don't know if that's a dynamic here, but that's not a very good justification for not complying with public records requests. So what's the timeline? What's the projected timeline on this litigation? Kelsey, you can talk a little bit about that, and whether Aisha, Amara, and Taiwo are going to still be Yale students, when this thing gets resolved.
I hope so. Yeah, it's a little bit hard to predict. Litigation is generally kind of slow and can be frustrating, but this is a discrete legal issue, and we filed the complaint, and the answer is due, as Amara mentioned, in just a couple weeks. So we're hopeful that we can move forward to a decision on the merits in the next coming months. But it is hard to predict because it depends on what else is on the court's docket and what happens with motions in the litigation.
Yeah. So what does discovery look like in this kind of case? Do you have a sense of that?
Yeah. So in the typical FOIA case, sometimes discovery isn't used because it's just a question of, is this exemption applicable? And then the government will submit an affidavit and the other side will counter. This might be a case in which there are factual issues to explore. And so we don't know yet, what that will look like. Certainly, we are confident that the facts are on our side to demonstrate that both West Point and the Army West Point Athletic Association have an obligation to comply with FOIA and need to turn over these records to Daniel as soon as possible.
Yeah, well, I hope so as well. This has been a great discussion. I want to thank you all for being willing to talk about this. And again, we're taking this stuff, and this has been a conversation that I think a lot of athletes may not be instinctively drawn to, but we're trying to take it where they live and to package it in a way that resonates with them. And I think that talking about this in terms of accountability and transparency, when so much of the decision-making in college sports is really off the radar, I think that this is going to be very valuable for them. So I really appreciate your time. And I would love to talk to all of you again on the backside once we get a final decision and ask some of these same questions on how this case has influenced your thinking about our relationship to government. So thanks again. And we will certainly keep an eye on your good work.
Thank you so much for having us. This is awesome.